Hello, my name is Ken Woodland, and today I'll be discussing cases related to local taxes and collections. My first case is Cali Family Limited Partnership v. Milton. This case arises out of tax assessments levied on real estate owned by the Cali Family Limited Partnership for multiple years dating back to 2002. After failing to seek tax abatements pursuant to General Law Chapter 59, Section 59, Cali brought this lawsuit alleging that the town was unjustly enriched by what Cali described as excessive tax assessments. On appeal, Cali argued that the trial court erred in concluding the remedy of abatement in General Law Chapter 59, Section 59 was Cali's exclusive remedy. Ultimately, the appeals court disagreed with Cali and upheld the trial court's decision in this case. So what happened here? A Mr. William Adams, who is a general partner of Cali, received title to certain lots in 1999. After certain conveyances, redrawn lots, and a sale, Cali continued to own two adjacent lots, number 14 and number 33. Dating back to 2002, Cali received tax bills for lot 33 that were not paid and for which no tax abatements was sought. The taxpayer testified that his house was on lot 14, whereas lot 33 remained unimproved, and that Cali received separate tax bills for each. While Cali paid the lot 14 tax bills, Cali simply disregarded the lot 33 tax bills because Adams thought the assessed value of lot 33 was excessive. Ultimately, in 2014, the mortgagee of the lots paid the $50,000 plus tax lien that had accrued on lot 33. Cali is now repaying that amount plus interest to the mortgagee. Cali then brought this lawsuit, asserting a claim for equity, in which Cali argued that the town was unjustly enriched by the lot 33 tax assessments. It was noted that Cali did not introduce any expert testimony regarding what the value or the assessed value of lot 33 should have been. Before we discuss how the court reached its conclusion, what is unjust enrichment? In essence, the doctrine of unjust enrichment allows a plaintiff to recover from a defendant, usually without the benefit of an enforceable contractual obligation, where the defendant has unfairly benefited from the plaintiff's efforts, and that benefit is against the fundamental principles of justice or equity and good conscience. As applied to this case, the taxpayer is basically saying, though they did not file for an abatement, for the town to keep the proceeds of what he alleges is a great overassessment is not fair and should be remedied by the court. As I previously mentioned, the court disagrees. The court sides with the town. This was a simple question of assessed value that should have attempted to be resolved through the abatement process. However, the court adds that while the remedy of abatement has been described as an exclusive remedy, the exclusivity of the remedy of abatement, quote, has taken on a paradoxically relative character, end quote. What does that mean? The court says, though abatement is the exclusive remedy, there are nonetheless situations where the court has entertained exceptions to that rule. These include if the administrative remedy is seriously inadequate, or if the case involves novel questions, repetitive problems, or is in the public interest. The court concludes that none of these exceptions applies to the case at hand. In this circumstance, the trial judge was correct that Cali's exclusive remedy was the administrative remedy of abatement. So what is the main takeaway from this case? The general rule of a taxpayer's exclusive remedy being the remedy of abatement pursuant to General Law Chapter 59, Section 59 is still intact. But the court notes that while unjust enrichment does not seem like a valid argument constituting an exception to this general rule, there are limitations the court has recognized.